All right, we're going to look at standard number one, professionalism. Let me tell you the basic approach that we'll take as we go through each of the subsections of standard one. So standard 1A is about the knowledge of the law, and we're going to go through four basic steps as we review each of these substandards. First, we'll look at the conduct required by a standard. So in this particular case, standard 1A, which is knowledge of the law. We'll look at the key concepts that evolve around the knowledge of the law that you'll need to know. We'll look at a few case studies and give you an opportunity to think about how different fact patterns evolve and how the different standards may or may not apply. And then we'll look at very specific compliance practices to ensure that you are complying with each of the standards in the Code of Ethics. All right, so here's some general knowledge. So members and candidates must understand and comply with all applicable laws, rules, and regulations, including the CFA Institute's Code of Ethics and Standards of Professional Conduct. So this includes any government, regulatory organization, licensing agency, professional association governing their professional activities. In the event of conflict, members and candidates must comply with the more strict law, rule, or regulation. Members and candidates must not knowingly participate or assist in and must disassociate from any violation of such laws, rules, or regulations. So here's some key concepts. First of all, you need to know what law is applicable, and then understand the relationship between the code and the standards and the applicable law. Which is the more strict rule? Whichever is the more strict rule is the one you want to follow. And then you need to know how to disassociate from violations by others. So if you know somebody is violating a law or a standard, you need to not be involved in that. And you may need to take additional steps as well, and we'll look at that in a moment. So while you need to know the laws and regulations of the environment that you're operating in, the country you're operating in, you're not required to be a legal expert. Instead, you should know how to get compliance guidance. You should know which attorneys to speak with, or what regulatory bodies to speak with, or know how to get in touch with the institute. And then also you need to be vigilant in learning about changing laws, because laws and regulations change on a regular basis, particularly as they relate to in the investment community. So you need to be very diligent and vigilant about that. So when we talk about laws versus codes and standard, follow the more strict course of conduct. For CFA Institute members and candidates, codes and standards are always applicable no matter what jurisdiction you're operating in. You cannot violate the code and standards even if the conduct is legal. Okay, so keep that in mind. And you always want to follow the more strict law or regulation. So investment professionals are responsible for legal and ethical violations of others in which they knowingly participate or assist. So to dissociate from the activity by stopping the activity, stepping away, contacting the compliance officer or body, and if necessary, seek other employment. That is, leave your position and go elsewhere. But it's very important that if you know somebody is violating either a law, a rule, or a standard, then you need to walk away from that. So report violations of codes and standards by members or candidates to the CFA Institute, and report legal and ethical violations to regulatory authorities when either mandated by law, on a voluntary basis if you choose, or when it protects clients or public interests. Okay, so we can't simply ignore them, can't simply walk away from them in many cases, particularly if it involves protecting clients or public interests, or if it's mandated by law. Okay, let's look at some specific cases and then see how standard 1A, knowledge of the law, either applies or doesn't apply. So scenario one, Colleen White is excited to use social media to communicate with clients and potential clients. She recently began posting investment information, including performance reports, investment opinions, and investment recommendations to her Facebook page. In addition, she sent out a brief announcement, opinions, and thoughts via her Twitter account. For example, prospectus for future growth of XYZ company look good. Money making opportunity hashtag. Prior to White's use of these platforms, issue, her regulator issued new requirements governing online communication with clients. White's communications appear to be in conflict with the recent regulatory changes. Before using social media, White should have what? A, studied the new legal requirements for online communication. B, checked with her firm's compliance department. D, not engaged in the activity. So think about this before you look at the answers. So while all these answers might appear to be good ones, let's take a look and see what the best answer is and why. So the best answer here would be checked with our firm's compliance department. Now, A certainly would have prevented her from taking this activity, but she's not required to be an expert. She's not required to read the laws and rules and be an expert on them, but she is required to seek advice from those who are in the position to know about compliance, and that's what she should have done. And if she had done that, then she would not have engaged in the activity. Okay, let's look at the next case. So Camisha Washington firm advertises its past performance records by showing the 10-year return history of a composite of its clients' accounts. The description of the composite on the advertisement states that all client accounts are included when calculating the composite return. Washington discovers, however, that the composite omits the performance of accounts that have left the firm during the 10-year period. This omission has led to an inflated performance figure. Washington's supervisor has made it clear that Washington is expected to use promotional material when soliciting business for the firm. What should Washington do? So again, think about the different situations. Is she would following her supervisor's recommendation be a violation of Standard 1A? And if so, what should she do? Even though Camisha did not prepare the report, the use of it would be a knowing violation of Standard 1A because it does not provide the full picture and put the interest of her clients in the general public first. So her best course of action would be bring the error to the attention of her supervisor and, if appropriate, the firm's compliance department. If they decide not to update the materials at that point, then she'll have an additional decision to make. But her first step would clearly be A, bring the error to the attention of her supervisor and the firm's compliance department. Okay, so let's look at the compliance practices. So we want to adopt robust compliance policies and procedures. We want to stay informed through continuing education. We want to keep a current copy of rules, regulations, and laws available so that we have them as reference material. And we want to maintain rigorous compliance resources. In addition, we want to provide regular education and training. So to summarize, we're always required to abide by applicable laws. Applicable law is what governs conduct. And so it's going to vary from country to country, and it may even vary from one state to another. But generally speaking, each country is going to have their own laws and regulations with regard to investment actions. And so keep in mind that we always want to take on the more stricter regulation or standard, and we're always have to comply with the code of ethics, the stance in the code of ethics. So we're not required to be legal experts. We have to consult for compliance. The code and standards are always applicable, and when in conflict, follow the more strict rule. And then if we know of a violation by others, either people or organizations, then we have to move away from that and take the appropriate action. Okay, so let's move on to the next section, which is independence and objectivity, standard 1B. All right, standard 1B deals with independence and objectivity. So this is what we plan to cover in this section. We're going to understand the required conduct, be aware of potential ethical dilemmas, know how to respond to those ethical dilemmas, be able to identify situations that could challenge independence and objectivity, and be able to describe how to maintain independence and objectivity in the face of potential conflicts. So, as a general overview, members and candidates must use reasonable care and prudent judgment to achieve and maintain independence and objectivity in their professional activities. Members and candidates must not offer, solicit, or accept any gift, benefit, compensation, or consideration that reasonably could be expected to compromise their own or another's independence and objectivity. So here are some of the key concepts of standard 1B. Challenges to independence and objectivities, gift from clients, and compromising the independence and objectivity of others. So clients benefit from the independent and objective work and opinions of investment professionals. That's what they're paying us for, right? To provide them independent and objective observations. Clients expect investment recommendations based on independent thought, right? So we're not being influenced by firms or managers or whomever. And standard, as a footnote, standard 1B is closely related to a standard we'll look at later, standard 6, conflicts of interest. Investment professionals can have challenges from various sources. Corporate issuers, outside vendors and service providers, business or personal relationships, and employers. So there's lots of people who want certain things, and sometimes those are in conflict with our independence and objectivity. So we have to be aware of that, right? So if I'm issuing stock, I'd like investment professionals to speak highly of it. Sometimes vendors and service providers want certain favors or perspectives that would make them look better. And certainly business, professional relationships, and employers are all potential areas. So challenges from inducement, so there could be gifts and benefits, travel and accommodation, investment opportunities, personal relationships, business relationships, compensation, threats to continuing business. All of these things have the opportunity to act as inducements and impair our ability to be independent and objective. So gifts from clients can be distinguished from gifts or consideration from those seeking to influence to the detriment of our clients. So this is considered gifts, they're considered supplemental compensation, reward for a good job versus seeking advantage over other clients, and it should be disclosed to the employer if we receive a gift. So we'll look at that a little bit in the case studies in a minute. So we cannot compromise the independence and objectivity of investment professionals. Any gifts that go beyond normal course of business or pay to play are things that we really have to avoid. All right, let's look at a few cases. So the first one, Davis, an analyst for an asset management firm, attends a presentation for security analysts at the headquarters of a manufacturing company. The analysts are very impressed with the presentation and ask the CEO many questions. After the meeting, the head of investment relations invites all analysts to a clubhouse for dinner and karaoke. Most of the other analysts accept the invitation. What should Davis do? Accept the invitation? Accept the dinner but not karaoke? Decline the invitation. So there can be a case made for A, accept the invitation, particularly if it's going to dinner in the normal course of events, but we certainly want to avoid an extravagant dinner. And the fact that there is some kind of a karaoke entertainment thing associated with it uh, appears to be a little bit over the line in terms of the potential to either really or at least perceptually interfere with the independence and objectivity of the analyst. So because of that, the best practice would be C, to decline the invitation and to do your due diligence. All right, let's look at the next case. Next case, Grant directs a large amount of his commission business to a New York-based brokerage house. In appreciation for all the business, the brokerage house gives Grant 2 tickets to the World Cup in South Africa, 2 nights at a nearby resort, several meals, and transportation via limousine to the game. What should Grant do? So this one is a little more clear-cut. In this particular case, A is clearly appropriate. That Grant should not accept the tickets and travel accommodations. It really boils down to independence and objectivity. That accepting such a large and extravagant gift has both the perception and the reality that Grant's independence and objectivity may be compromised. And if that's compromised, then Grant cannot do what's in the best interest of the clients. Okay, next one is Grant manages the portfolio of Ian Nolden, a client of Tisbury Investments. Grant achieves an annual return for Nolden that is consistently better than that of the benchmark she and the clients previously agreed to. As a reward, Nolden offers Green 2 tickets to Wimbledon and the use of Nolden's flat in London for a week. What should Green do? So in this particular case, C, accepting and disclosing the receipt of the tickets and travel to her employer would be acceptable. And so you might wonder, well, why is this acceptable when the previous one was not? Well, the previous one involved a relationship where it might be influenced to lose one's objectivity or independence by accepting the gift. In this particular case, it's a client who's giving a gift to the investment analyst, and that accepting that gift, as long as it's disclosed to her employer, it is not likely to influence her objectivity or independence. All right, so there's a couple more cases here that I'd like, one more case here that you should take a look at. And now I'm going to wrap up in terms of independence and objectivity. So compliance practice, adopt robust compliance policies and procedures regarding gifts, travel reimbursements, and special cost arrangements. Okay, so we want to have policies in place so that there's no question that comes up when these things occur. Report any personal investments that you're making, disclose personal or business relationships, and manage compensation arrangements. So to summarize, required to maintain independence and objectivity. Challenges come from many sources. Challenges can be gifts, benefits, compensation, threats to withholding business. Gifts from clients may be accepted under certain circumstances, as we just saw, and as long as they do not compromise the independence and objectivities of others.